G'day there guys, it's your main man Markee, back at it again with r/Legaladvice. Now if you love this video like I love you, I want you to sit back, relax, chuck a like on the video, prawn on the Barbie, and enjoy the content. Posted by user Favor the Bold, titled, 10 years ago I co-signed for a friend so he could get a federal education loan. Recently, he has started becoming a delinquent with payments. Is there anything I can do? Like it says on the tin, it hasn't reached a point where anything has been forced on me yet, but I got a letter saying that he was 15 days late. Then a couple of weeks after the Federal Loan Service called me, and this is the first time they've done that. The guy in question won't answer my texts anymore, probably because I've made it clear he's not my friend anymore and I'm ticked. Is there any point at which I can take legal action against him? He's probably only 30 days late at this point, but I guess I'm actually worrying more about the future. I know he has a job because he's a nurse, so if they needed to garnish someone's wages, I assume it would be his. But is it possible I could be garnished as well? Also, since we aren't really in contact anymore, I have no idea if he still does have a job though. I assume he would be getting unemployment if he lost his job, and that at least could be garnished, right? Also, I realize now I should never ever co-sign for anyone, and I never will again. I was a youthful 30-year-old at the time, having come from a very sheltered home to my first job in the big city at that time. Really, I lived at home until age 29, and he was one of my very first boyfriends. We had already broken up by the time he asked for me to co-sign, and he had assured me he would pay off the loan within a year because he was getting an inheritance from his grandmother's death, and I knew he owned a house because he had inherited it from her. I don't know if all of that was lies or if he just decided to use the money for something else when he got it. Whatever the case, if I had known I'd still be on the hook 10 years later, there's no way I would have done it, even as a naive 30-year-old. I live in Dallas, Texas, USA. By co-signing, you take full responsibility for the loan if the primary party, him, is unable to pay. Ask about a co-signer release, or refinancing the loan without you on it. While there's no harm in asking, the odds of getting either are so close to zero, it's not even funny. Even in the unlikely scenario when the former friend would release OP, the bank would not accept removing a person that can pay to only leave a person that cannot pay responsible for the remaining loan balance. Unfortunately, odds are that OP may be stuck making the loan payments, and their only remedy is to sue their former friend for the money they're out, which, given the person is already in financial trouble, is unlikely to help much. My co-signer is dead and the loan company is still being an ass about the co-signer release. I haven't missed a payment in 9 years. Sorry to hear about your loss. Any idea why the bank is still hoping a deceased person may help pay your loan? Probably just keeping an option open so they can go after the estate's assets if they need to. While theoretically possible, it seems highly impractical, since the loan is being paid and the estate will be settled, leaving the lender with no recourse until a payer that paid faithfully for 9 years suddenly defaults. But yes, I can see how a lender would like a few more months of cosigner availability. And OP replies to this, okay, this is actually what I was asking about. Can I sue him if I have to pay? The answer seems to be yes, so that's a positive here. I was finally able to get him to respond to my texts today by threatening to call his job if he didn't respond. He claims that he's looking into getting me off the loan and that he's working with FedLoan to adjust his payments so that he can handle them. Impossible to tell if any of this is true, but knowing I can sue him if I have to pay anything is a comfort. Can I use his texts to me about trying to get me off the loan as evidence that I shouldn't be responsible for the loan in small claims courts? I'm not sure how much I care about the credit being affected. Currently, my credit is not great because of my own mistakes a couple of years ago, but I've been faithful the last 2 years trying to rebuild it, and any missed payments don't help that cause. But I can't say how much harm he's doing to someone with only fair credit right now. The only way to get you off the loan, if it's a federal loan, which I'm guessing is a federal grad plus loan, is if he consolidates. Thankfully, there's no credit check for those, so there's absolutely no reason he will be denied. He can do it online at studentaid.gov. You can help convince him to do it by telling him it will also lower his payments, which it will due to the longer term they will give him. Masterbro says, it is not only his loan. By co-signing it, it is your loan as well. You are 30 days late on a loan. You are past due on the loan. Your credit will suffer if you do not pay the loan off. Your wages can be garnished. This is what co-signing a loan means. You can pay the loan amounts and then sue him in small claims court, if there was some kind of agreement that he was going to take care of the loan. Simply not paying the loan because he said he would is not an option and will cause you to default. People lie, as you learned since. I'm sorry that you have to deal with this, but legally there is not much you can do other than pay your loan payments and sue your former friend for that money. Update: 10 years ago I co-signed for a friend so he could get a federal education loan. Recently he started becoming delinquent with payments. Is there anything I can do? And in case anyone wanted an update, I thought I'd share. What happened is, to my surprise, he actually finally did get me off the loan by refinancing. I was so sure he would never let me off the hook, I actually tried getting him to come with me on judge duty, because the producers pay your judgment if you win. But that turned out to be unnecessary. Why he chose this particular moment to finally get me off the thing, why he didn't get my name off of there the first few times I mentioned it, over a decade of time, I have no idea. I'm going to assume that insulting him and threatening to put in a complaint with the nursing board and his job did the trick. FYI, I did call Fed Loan to make sure he wasn't lying to me about it, and the loan is already showing paid off on my credit reports. May I never cross this motherfricker's path again. Location: Dallas, Texas. Posted by user TaylorGBBO. Titled, Neighbors reports my car to be towed every day despite having a permit. So I recently came back from college and I couldn't get a parking decal from my property manager's office since they're closed. I live in Fort Lauderdale. However, I was able to get into contact with someone and was given an online permit to prove that my car can legally park there. This is an official permit that I paid for that doesn't expire until July 1st. However, my car gets towed every 2 a.m., and I have to pay the driver $60 every morning despite showing him my decal. He says that although the decal is official, the head of my HOA who lives in my neighborhood keeps reporting my car to get it towed, and once he gets the order, I have to pay him to get my car back. As much as I hate to be this person, I am the only black person in my community, and he has made it clear that he doesn't like my family living there, and had always given us a hard time since he moved in 3 years ago. My family has lived here for over 23 years. Is there anything I can do legally about this? Thank you. Duke Beekeeper's Kid says, read through the comments to glean your response. First thing is that the HOA must, and in writing, authorize the tow of a vehicle parked on the property without permission if a sign is posted. The authorization must be made in writing. If the tow truck driver doesn't have this on him when the car is hooked up, it is theft. Additionally, any rebate from the towing company to the property owner or agent is prohibited as per Broward Country rules. 1. If you have a permit and the tow truck driver is attached to the car, it is theft. Call the police and get a police report for every instance. If the tow truck driver passes the blame to the head of the HOA, then have the HOA guy charged as well. But most importantly, press for charges on the tow truck driver as a person. The tow truck driver will talk to his people and his associates in the industry. Make sure he understands he's stealing the vehicle under the excuse the HOA wants it. The permit implies permission, and with that, he cannot lawfully take the car. 2. File a complaint about the towing company by calling this number or texting this number, both the county complaint lines. 3. Reach out to all board of the HOA members and explain he has made it clear that he doesn't like my family living there and had always given us a hard time since he moved in 3 years ago with a video recorder in their face. Then mention that the federal courts in Reeves versus Carrollsburg found that a condo or HOA couldn't sit idly by while one of its owners was being attacked on the basis of her race. This means the association cannot ignore the problem. While you're chatting with the HOA, make sure it is understood that if the head of the HOA is going to continue with his harassing or retaliatory behaviors, the HOA will be liable, as he is acting as and for the HOA. 5. Get an attorney, and have them take the HOA and the tow company to court for illegally towing your car. Someone else asks, how many days has this happened, and how much money have you been forced to pay total? People who know more than me can OP sue the HOA or the guy harassing them to get that money back. Taylor GBBO says, this happened 5 times so far, and for a total of $300. Small claims court will help recover that money, but you need to first put a stop to this guy having your car towed. You need to have whoever you spoke with regarding the parking permit / whoever is in charge of parking to speak with the towing company and let them know to ignore that dude. Get your money back from the HOA president in small claims, not the tow driver. Since he called and he told the tow company to ignore your permit. Not only is the tow guy just doing his job, aka not in the wrong, but by having the HOA pay, you make the president lose HOA money, which you can then get the other association members to harass him about at the next HOA meeting. Try to see if anyone else has the same permit situation as you, but are not getting reported. This will help build your case. Not a legal expert in any way, but I would see if this could be filed as harassment. Also, contact the person you used for the online permits. Towing company do have rules that they have to follow. See with your city if his actions are legal. Did you ask the HOA, not the tow truck driver, why your car was towed despite having a permit? I'd have to ask my mother, as I don't know much, but I'll see if she did. How would he know you have a permit if it's not on your car and you haven't spoken to him about it? Last time I got towed, I had the permit on the car, but they still attempted to tow it. I just don't think the tow driver cares at all about the permits. They got called out and they want their money. It's the guy reporting the car that needs to be spoken to. That's what I figured. I already have a bone to pick with that guy, so I'm going to go and talk to him about it today about all of this. I assumed there is a printed out copy on the dashboard. If not, that's something that still should have been communicated between the person giving an online copy and the person reporting the car. They should be in contact with each other. Our property manager simply said that they will know not to tow your car, without the printed permit being on it. I see now that it's clearly not the case. Felix Golden has a really good response here and says, if this person is the president of the HOA, or at least a board member, he is in for a world of hurt here, and possibly the association as a whole. What you are describing is potentially a violation of the Fair Housing Act, a federal law that, among other things, prevents discrimination on the basis of race, color, sex, family status, etc. in housing. Among the various items that would qualify is the limiting of privileges, services, or facilities of a dwelling. Repeatedly having you towed could be considered denying you of a privilege afforded to you by living there and having a permit. This could possibly be considered harassment instead, or in addition to the depriving of privileges. The property manager / management company works for the association, and in Florida, a property manager must have an LCAM license, Licensed Community Association Manager. They can lose their license for allowing the association or members of the board to commit violations like this. Also, when vehicles are towed at the request of the association, the tow truck driver must fill out paperwork with the details, get the signature of a person from the association authorized to order the tow, and submit that to the police. Have they been doing this for every tow? If they haven't, this is highly illegal. The amount they are charging is actually low. It is less than half of what they are allowed to by Broward County's schedule of maximum tow fees. And I don't know any tow company that doesn't want to charge as much as they are allowed. If they have been submitting the paperwork to the police, or at least have a copy of it, you need to get a hold of those copies to see if this neighbor has signed it. It's all about the paperwork. If there is no signature, it's an illegal tow. If he has signed it, then that puts the association on the hook for potential discrimination. I doubt the rest of the board members, the property manager, and especially all the other homeowners want to be associated with this type of claim, and I would hope not. The association is owned by all the homeowners and elect the board to run it on their behalf. They generally don't like when board members cost them money on lawsuits, but lawsuits can get expensive. Associations should have insurance to cover legal fees for actions by the board members and employees. But if the action itself was not simply an error performed in good faith or an omission, especially if malicious intent or illegal action is involved, those policies may not necessarily apply, and the association would have to pay for the cost of defending that action, and the individual board members can also be sued directly. Get and keep together any copies of any paperwork, including emails and other items from the property manager, as well as tow slips and receipts. Print out everything that may only exist electronically. Speak to the property manager about the first. Also, keep in mind that if you file an FHA complaint, any retaliation is also considered a violation of the Act. Now, OP does several edits that says, "Edit, thanks all for the help everyone. I have no idea how to contact HOA or the property manager, as my mother deals with them, and every time the car was getting towed except the last time, she was the one to catch them and pay. I will be contacting the HOA with her when she gets home, and will try and contact the property manager. My neighbor is a dick, and I will also be speaking to him personally when I get home. If legal action needs to be taken, we will definitely do so. Thank you." Edit, talked to the property manager, and they said they rescinded my permit. I asked them why, and they said that they aren't doing those anymore. I told them they never gave me any indication of that, and they said they did not plan on giving me any notice. Edit, final update, thank you everyone. I honestly could not have expected to get this much help. As of what happens next, we plan on taking legal action, mainly to get our money back, and because it seems that what may have happened with the permits wasn't strictly legal, I still need to talk personally with the HOA guy, who conveniently doesn't answer his door when I knock, but he has 2 big-ass dogs, and we'll have to walk them eventually. It seems the HOA tends to suck, especially in South Florida. Thank you. Or wherever SoFlo is. Posted by user, Let's Be Honest, Punny. Titled, "I was filmed without my consent during a sex act by my ex. His new girlfriend posted those videos online, and my entire Instagram followers list got the video. How to proceed?" So I'm using my sister's account to post this. She understands Reddit, I don't. She will be checking for the post for updates for me. I live in Canada. They, ex and his new girlfriend, live in the US right now. I have filed a police report in Canada, but I don't know what else I can do to get this to stop and to have them charged. The Canadian police don't seem to have many answers for me. Any advice would be helpful. Before they hide the evidence, take as many screenshots as you can, including any messages regarding the video between you and the other 2 parties. You need to prove your case. Do you know what state they live in / posted from? Different states have different rules that might help you. Indiana. Indiana allows civil action for revenge porn. I would try to find a revenge porn attorney. If there aren't any specialized attorneys in the area, call around reputable personal injury firms to get a consult on your case. Keep records of everything and do not contact your ex or his girlfriend moving forward. Also contact the police. Posting revenge porn is a misdemeanor. If it's her second offense, it's a felony. I'm sorry that happened. Here are some resources for you while you pursue legal recourse. They may also help you gain ideas. The Cyber Civil Rights Initiative is a survivor-led organization for victims of non-consensual pornography. They offer a 24/7 crisis line, referrals to pro bono and low bono attorneys, image removal guides, tech policy work, information about state and international law around NCP, research on NCP, etc. The Without My Consent is similar to Cyber Civil Rights Initiative, although they have now been folded into CCRI. They offer a helpful Something Can Be Done guide for survivors of NCP. And Cool Army is similar to the above, but they also offer an online support group for NCP survivors. Posting revenge porn and making secret recordings of intimate acts that were made without your consent are strong grounds to pursue criminal and civil cases. I read that he is now in Indiana, but these acts have now been explicitly made illegal in many jurisdictions around the world. Since the postings were done on a social media site, that social media site can be held responsible for being a party. You can safely bring lawsuits against not only your ex and his current girlfriend, but also seek damages from the medium that enabled these acts. It's only a matter of retaining lawyers and filing cases. Your expenses will be covered and you will most likely win substantial amounts in compensation. I would try and download the copy from any site you've seen it on. There may be metadata in the file pointing to the exact location of upload or source. Say if it was an iPhone or geolocation. Time and date stamps for exact confirmation. Then I would contact the site administrator to see if they can take it down and provide any further info. Update. Thank you all for the advice so far. I totally understand why this was locked. Thank you for the explanation mods. Posted by user Cavalry Medic, titled WV, Hospital Refusing Wife to See Newborn. This is medicine and malpractice. My wife went into labor at 2000, 6th of June 2020. It was a very difficult labor and ended with us almost losing the baby and having an emergency C-section, which was terrible enough on its own. After she came out of recovery from the C-section, they are refusing us to access to the baby. 12 hours later, we still haven't seen her. They aren't letting us see her because my wife is an employee of the hospital in the ED, and they want her to have a COVID test before either of us are allowed to see the baby. I'm not allowed to leave the recovery room at all to go anywhere. No one is able to provide us any policy or any documentation that states that a non-symptomatic mum has to be isolated from the infant until results are back. No other mothers on the floor have been tested for COVID or isolated from their infant. Also, our infant has been isolated and not in the standard nursery. My wife is extremely distraught. She is already having nightmares because the C-section was so traumatic, and now she is feeling inadequate and afraid the baby won't bond with her. We are already in contact with her PCM to get therapy lined up. Do we have any legal recourse to ensure that this doesn't happen to anyone else? Sorry if this seemed like incoherent rambling. I'm still speaking from emotion, so my logic may be shaky. This is highly abnormal. Is the infant showing symptoms of COVID? You can start by talking to the hospital ombudsman to try to get to the bottom of the issue, but no, the hospital cannot refuse you access to your child without a court order. Is the infant in the NICU? Does the child need ongoing medical care? If you cannot work things out with the hospital, you can consider leaving. No one is symptomatic. It was only prompted because my wife is an RN in their ER. She's only treated 2 positive COVID patients, and that was over 4 weeks ago, and she was wearing full PPE. Baby has not been in the NICU or any special monitoring. They told us our only option was to sign out AMA, but that left us in a hard place, because it can compromise insurance payments. I was also not allowed out of the room to do anything either. I was not tested, and it was not required that I be tested. I guess I'm frustrated more than anything. What happened to us is over and done. I just really don't want anyone else to have to deal with this. Leaving AMA does not compromise insurance payments, which is a common myth, at all. You can leave when you like, and insurance will pay for bills up until the time you leave. Thank you for that information. Does this still apply if there is a complication after they leave the AMA though? If a person leaves AMA and ends up back in the hospital for a complication related to the care they refused when they left AMA, can insurance deny those further claims? No, they can't. People do stupid things all the time to hurt themselves. Those claims aren't denied. Neither is leaving the hospital before being discharged, or waiting too long to go to the hospital or doctor and having a condition get much worse than it should or would have. Someone else says, "This sounds like some hospital administration garbage. Call your OB-GYN right now and tell him or her the situation. That should get it sorted out. If this happened to my patient, I would be a firestorm on the phone." Other avenues are to demand to speak with a charge nurse, social worker, hospital administration, the patient advocate or ombudsman, demand to see the policy they're referring to, call the police and tell them your child is being withheld from you, demand to speak to the on-call pediatrician, demand to speak to the hospital legal department or risk management department. All of the above options have ways of being reached on the weekend and in an emergency. And now, update. We have possession of the baby now. Baby is latching and feeding. However, I don't want to just let this go. I am 100% not okay with the way we were treated, and I'm not just going to let it go because we have her now. Looking forward to see any further updates, but there's your update for this one, guys. Posted by user FrinXish, titled, "In Need of Help. 17 female being forced to stay with my dad for a month due to court order. The judge refuses to listen to me or my little brother, 14, and is doing everything in favor of my dad. This is in Colorado." So my parents divorced 2 to 3 years ago, and it was pretty nasty and stressful divorce. My dad is verbally abusive and has been physically, and I hope only just to me. It would be torture to me if he had done this to my brothers, and sexually abusive in the past. Despite the efforts of me and my little brother sending multiple letters to the judge and begging my mum constantly to fight harder for us to stop going to his house, the judge that works in the case keeps filing in my dad's favor. According to my mum, he yelled at her in court and told her she was stupid for filing to restrict parenting time against my dad, which she had done because my younger brother and I requested it. My dad has been lying in court, saying that my younger brother and I love it at his house and we're always excited to go. However, my dad refuses to get us basic everyday necessities, toiletries, clothes, etc., that he has been court-ordered to get for us. He also ignores us all the time and provides no entertainment. A couple of weeks ago, he made us go over to his house for the weekend, and alas, he ignored us again. I was stressed the entire weekend, and when I found out that he was making no plans to return us to our mum, I flipped. He had told the police, who had followed my mum to his house, that he wasn't planning on returning us to the 15th, and my mum hadn't been replying to his messages, so he just went through with it without asking for an agreement. I became overly stressed because I never even wanted to be there in the first place, and there was some yelling back and forth. It ended while my dad was on the phone with the police, and my dad just pushed me into a flight of stairs and threw a bucket that originally had my stuff in it at me. He was holding me down, and when he had pulled back his fist like he was going to punch me, I pushed him away with my feet. He told the police that I had assaulted him, and he wanted to press charges to throw me in jail. I had a panic attack in my room from the stress. Police didn't press charges, but he had to return me to my mum's house until the next court date, which was yesterday. The court is giving him a month of make-up time, starting today, and made an order saying that my brother and I are not allowed to testify in court. The cops have also told me to stop calling them because they think it's a waste of their time. I'm afraid that my father is going to harm me and my little brother, and make efforts to keep us away from our mum for as long as possible. He also says rude things about my mum almost all the time, and I don't want him to alienate my little brother. What can I, a 17-year-old, do? Call Child Protective Services today. You are being physically abused. Push to get yourself and your brother a guardian ad litem. They will represent your interests in court. One of their first actions should be petitioning for a new judge. Since you're in Colorado, here is the hotline information for the CPS. You need to call and give information, give dates if you can, and if you took pictures of anything, like bruises, or have texts of verbal abuse, mention that too. You don't have to tell your dad that you called. Even if you reveal your identity when you make this call, CPS has to keep the information confidential. CPS is better equipped to deal with child abuse. If something new happens after they interview you, you can call again. You've got some good advice here already, but I wanted to ask, have you been documenting the abuse at all? Photos of lack of supplies, bruises, journals kept documenting all the abuse. If you haven't been writing down what's been happening, I suggest starting now. Do you know the neighbors at your dad's? Would they have heard any of these attacks against you and vouch for you? Definitely start with a call to CPS. I'm sorry you're dealing with this. I only know one of the neighbors, and it's an elderly woman who doesn't take too kindly to my dad. I have pictures of some of the injuries that I've gotten, and many recordings of my dad, but the judge doesn't want to look at it. Good. This is what CPS needs. Call them and tell them that you've been hurt in the past and that you don't feel safe. And now, update. So today I didn't have to go to his house. He has a court order saying he has to pick up both me and my brother at the same time. However, despite this, he tried to drag off just my little brother. He grabbed him by the wrist and started physically dragging him. I hit him once and he let go of my brother and started attacking me. I have bruising in my upper abdominal area from him punching me. Luckily, we have security footage and I was sent to the ER to make sure I didn't have internal bleeding. The hospital called CPS and my mum is going to call CPS and file for another motion to restrict parenting time, submitting a copy of my discharge papers as evidence. House we're about to close on flooded. Help. Hi, I need some advice here. My spouse and I are supposed to close on a house on Monday, Texas, USA. But now the house has flood damage because the seller hired incompetent people to move his washer and dryer, which caused a massive flood in the house. It damaged flooring in the laundry room, entry, and living room. The seller ripped the baseboards as they were also flood damaged. I should mention that we got a text from our realtor that said, the seller wants to know if he can start taking out the flooring, to which we said no, because we wanted the flooring company we would hire to do that. He did it anyway, and he damaged a tile on the fireplace in the process. Additionally, the seller had an estimate done for the new floors since the flood ruined them, and has only agreed to give us $4,000, but the estimate is for over $5,000. My spouse and I are feeling really stressed about all of this, and we think we should back out because this house is not the same one we put an offer on because of the flood damage. We would never have put an offer on this house in its current condition. Can we back out and still get our earnest money back? Did my time later, chumps. Says, yay, you haven't closed. So this is the seller's problem right now. You need to talk to your realtor and find out how they are going to mitigate the damages the movers caused. You should be able to walk away or push back the closing date unless the seller fixes the problems to a reasonable level of satisfaction. This could include pulling back and drying all the carpets, etc. Talk to your realtor. They have your interests in mind. If you really need it, contact the Texas Bar Association for a real estate referral. The realtor does not have our interests in mind. She has been unhelpful and seems to care about nothing but getting the sale. She's honestly terrible. My problem is, I would have never put an offer on this house in this condition, and I'm not comfortable signing until I have a licensed and bonded flood inspection report done by the seller, which I do not have right now. If the realtor won't push the date back, I am backing out and not signing, but I don't want to lose my earnest money. Then don't close on the house, don't sign anything. Talk to that agent's manager if you need to. Here's a Texas bylaws thing. You can check this and see if the realtor has any complaints against them as well. The site wouldn't work for me, unfortunately. Says it's having an issue connecting to the database, so I can't check, but that would have been great info to have. If you haven't already, try opening it in a few browsers on a laptop or desktop computer. Some of the texas.gov and related sites still work best in Internet Explorer of all things. Have a consultation with a real property attorney to review the contract. They should be able to tell you exactly what steps to take to get your earnest money back, and the money you spend for a consultation will be worth avoiding any missteps. Then, fire your realtor and get one with your interests in mind. But we're supposed to sign tomorrow. Don't sign. Why would you even be thinking about signing? Right now, the flooding is the seller's problem. As soon as you sign, it becomes 100% yours. You can always postpone the signing until you have time to fire your realtor and consult an attorney. I'm saying I don't have time to get a lawyer. Then make time. She can't physically grab your hand and make you sign. Don't get pushed over by this. Chat with a lawyer ASAP to see what you can do. And if that means you don't sign yet, then let that be their problem. Follow your lawyer's advice. Call several lawyers at 8 a.m. tomorrow morning and find the first willing to give an initial free 15-minute phone consultation. Follow their advice. Robbie Throw says, Source, I'm a licensed realtor. Good news, you've not closed on the property. Nearly all contracts in use these days are developed in consultation and with the approval of the National Association of Realtors. As such, there will be a clause, likely in the inspection area of your contract, saying the house must be delivered in the same or better condition as it was when the contract was agreed on. Please make sure, read and highlight this section on your contract and take it to your realtor's supervising broker. This is the person who is more or less the boss of your realtor, i.e., their license is hung in and held by this office. The house has been damaged. You should be able to be released from the contract. If the broker still refuses, contact the local area board of realtors and take this to the board president. You should also contact an attorney who specializes in real estate law. You can also lodge a complaint with the NAR, the National Association of Realtors, and their state equivalent. I found it. It's in the possession clause. Says exactly that. Seller gives buyer the property in present condition. It's not in the condition we signed for in April, so we appear to have a condition to walk and get our earnest money back. But where we're at, we think that if we get all the documentation of the repairs the seller did on the flooring and get a flood inspection report done, we would be comfortable signing. But all that is not going to happen by tomorrow, which is why we need an extension. Fantastic. I would contact the agent's broker immediately, explain the situation, and ask them to send you an extension to sign. If they refuse them, you're well within your rights to walk. She says she needs a couple hours, so I guess she's working on that. Or, knowing her, she's busy trying to find a way to say no and try to force us into signing. She has been the worst. That's unfortunate. I hate this side of realty. It's one of the reasons people see many of us as nothing more than used car salesmen. Keep putting pressure on her and CC her broker on any emails. Also, it's not a bad idea to screenshot your texts. Best of luck. Definitely, and thank you. There's a good reason I only text and email her. I do not trust her at all. She has been so dishonest, and she even yelled at me when she was frustrated that I was mad at the seller wouldn't give us more money to repair the flaws. But I can't fire her at this point in the process. Yes, you do have power. Talk to the broker, her boss, as the other poster has instructed you to, and deal with them here on out. Algebra Lover, and I said that intentionally wrong, says, make sure you get an independent inspector in there to be certain repairs were completed. You need someone with a moisture meter to check the flooring, drywall, etc. It should be someone with experience in water damage remediation. A friend was a seller in a situation like yours. In their case, they had to move out, and a pipe burst 2 days before selling. Their insurance company covered the repairs. Update. I sincerely appreciate everyone's help and input. I've never bought a house before, so this flooding incident has stressed me out quite a lot. I found the clause in our contract that states that the house must remain in present condition at the time of signing, so I feel confident that we could back out if necessary and retain our earnest money. Additionally, our realtor, after days of us asking, just now sent us the repair report from Stanley Steamer, and it looks really good. It was about $2,500 of repair and drying work done over 3 days, so we're now feeling confident that things were taken care of correctly, and once we get the new floors in, it will be okay. I truly appreciate everyone's help. Still hate our realtor. Oh my god, I would too. Posted by user Chuchumon, titled, Rental Agreement Signed and Deposit Sent for 2-bedroom Apartment. Just found out one of the bedrooms is locked by the owners. Hello Reddit. I'm moving to a new city, Alberta, next month, and will be renting a condo. 2 weeks ago, I signed the lease for a condo management company without going in person or sending a video of the place, which was a big mistake because of COVID-19. Today, I finally got the chance to video chat with the current tenant and found out that one of the bedrooms is locked by the owners and not available for use. The original ad stated 2 bedrooms, and I have emails with the condo management company that shows the ad. However, I realize now that the number of bedrooms is not stated anywhere on the lease agreement. Only the address of the suite is on there. Does this mean I have legal rights to the entire place? I have reached out to the person at the condo management company, and she says she's looking into it, and it was her first time hearing this, but I feel like they'll just chalk it up to inaccurate advertisement. What are my options? Any advice would be much appreciated. I'm moving in a month, so hopefully there's enough time to sort this out. Thanks in advance. Duck Diver says, talk to the management company about either having the room made available or getting out of your lease. Too much hassle to deal with that. The lease, by giving the address and presumably by its language, allows you access to the entire property. But busting down the door and then moving all their stuff out is going to be a massive problem and the wrong move. What a hassle. Just talk to the management company and say if that room isn't available for use, you will not take possession of the unit and will take action for breach. The easiest remedy will be cancelling the lease. It's unlikely the management company even knows of this. So is this a 3-bedroom apartment and you'll only have access to 2 of them? Or was it advertised as 2 bedrooms but 1 is not available? I'm not a lawyer, but I've read here that in Canada, it's a lot easier to evict a roommate than a tenant. The owner/landlord could be reserving a bedroom for themselves because of this. But if you need 2 bedrooms and the place functionally has only 1, it seems to me grounds to void the lease. It's a 2-bedroom apartment and only 1 is available. Would I still get my deposit though if I void the lease? Not a lawyer. If they don't provide the whole apartment, they are the ones breaking the lease. Unless the lease says otherwise, renting a unit at an address means the whole unit. Call the PTDRS on Tuesday and ask. It's a service offered by the provincial government to mediate disagreements between landlords and tenants. In my opinion, you entered into the apartment expecting a 2-bedroom apartment, meaning you expect to have 2 bedrooms. The owner only intends for 1 bedroom to be available. Clearly, there's no meeting of the minds, and the contract should be voided. You are entitled to your deposit back. You may have to go through RTDRS to get them to return the deposit. Update: the condo manager got back to me. Apparently, the owners are overseas and won't be able to open the locked room. The unit was intended to only have 1 bedroom by the owners, but the condo manager didn't know until today. They have offered to give me my deposit back. Thanks, everyone. Posted by user Lollipop. Titled, "Can my landlord make us pay $67 fee to pay rent online?" California, Los Angeles area. We have lived in this apartment complex going on the 4th year, and it was recently sold to another company. We received a letter stating that we are to pay online from this month on, which is wonderful as it's way easier than dropping it off. However, that is the only way we are allowed to pay, and we are just now finding out that they're charging a $67 fee to do so. As you can imagine, rent is already astronomical. Is this legal? Can they actually force us to pay this way and pay online? Can we make them give us an address so we can mail it or drop it off? We've been trying to contact the management company for 3 days. First because the website doesn't even work, and then because of the fee, and they are not answering. Anything we can do? Apologies if this is a stupid question. Thanks, LA. On all of those systems that I have used, if you pay with a card, it charges you a ridiculous fee. If you add your bank account and pay that way, it is free. Have you checked that? Hey, you were totally right. Thank you. Doing it by e-check is free, but the debt card is $67. We've been on the phone with the company for like 30 minutes, lol. Major shout out to you. Otherwise, we would have been losing that extra $67 every month. I owe you a round of beers, thank you so much. You might consider creating a separate bank account to which you transfer the rent every month from your main account. That way, the landlord doesn't have access to all your money, just that 1 bit of rent each month. With the direct link to your account, you're giving them very easy access to it. It's not unheard of for them to try to take the rent money out on the due date without you knowing until the money is gone. We are going to open a different account this week just for this. Thanks so much. While I'm not worried about them taking the rent out on the due date, I definitely do not want them to have access to the entire checking account. We do plan to buy soon, and when we leave, I don't want them deciding they can just take out whatever they'd like during the moving out process. I've never paid rent online before, so this is totally new. Thank you very much for your insight. If you are under an existing lease and it does not allow for charges like this, then it comes out of your rent. So if your rent is $1,200, you take out the service charge from that. While OP figured it out, in addition, California requires a fee-free form of payment. I didn't know that. Got any links? Just for the future reference for my friends that might be in a similar situation. Thank you so much. Most Google results return COVID-related, but this has stuff about how they must allow an option other than cash/electronic. And if you guys can find that one, I wish you the best of luck. Great article, and it addresses exactly this issue. Thank you. They also say that we did have a lease for the first year, and then the last few years have been technically month to month. And it's already been addressed, but they put an update anyway. Update, it's free if you're using an actual checking account and not the card associated with the checking account. Thanks to that user, you saved us a grip of money. Thank you. Posted by user, got a bumble my dude. Titled, Child Custody/ICWA. Can I prevent the adoption of my infant nephew and have him placed in my custody? Hello all. I would like to know if it would be possible to obtain custody of my deceased sister's infant child and prevent his adoption through the Indian Child Welfare Act. For clarification, my husband, family, and I are active members of the Kiowa tribe in Oklahoma and live within the tribal jurisdiction. We regularly participate in events and have a member involved in government. 2 years ago, my 14-year-old sister ran away from home, and earlier this month, her boyfriend informed us that she had passed away from COVID-related pneumonia. He also told us that he was putting her 1-year-old baby boy up for adoption. From the way he referred to my nephew, it sounded as though he was not the biological father of the baby. My husband, our extended families, and I would like to raise our nephew within our culture after 2 centuries of our native children being stolen and sold to white families or put into foster care. And from what I understand, the Indian Child Welfare Act is supposed to protect our right to retain our children. However, we may not be able to afford a lawyer for a drawn-out custody battle, and I would like some opinions on whether it is likely we could win custody if ICWA could help, and if certain information could push the odds in our favor. Thank you. Edits. Our tribe is federally recognized, and my nephew qualifies as a member since our parents are full native, 1/4 blood quota. Edit number 2. We took everyone's advice and called my tribe's ICW program earlier this morning to give a brief rundown of our situation, and we have a meeting planned for next Wednesday. We've also reached out to the boyfriend for further clarification. My sister had been living with a couple in Oregon for nearly a year, so it seems likely the baby was born there. But when I asked about custody, he became quite nasty and said that my nephew's adoption was already paid for. Usually Sonny says, you and your tribe would have to legally intervene in the case and get in touch with social services. Start with your tribal government. Just to supplement this, under ICWA, the tribe has the right to intervene at any time. Much case law interprets this as even after the trial is over. The tribe has enormous discretion in these cases. The same is not true for OP, as he does not qualify under that ICWA provision. This doesn't mean he cannot intervene, just that ICWA doesn't give as much to the individuals as to tribes. OP says, someone below mentioned that chain of contacts may depend on whether my nephew's been put up for private adoption or taken by the state. How would this affect the case? ICWA is a federal law that applies to all Indian children, regardless of whether they are in custody of a private adoption agency or of CPS and DFPS. Just to clarify, ICWA applies in specific foster care, termination, or adoption proceedings. ICWA does not always apply in all custody cases involving an Indian child. Yes, you're right. When I said all, I just meant that the applicability of ICWA isn't connected to particular agencies, for example, state versus private, but I'm glad you chimed in to clarify. The Sheba says, private and dependency cases are treated the same under ICWA. The tribe can intervene at any time, and I believe if the child is eligible for enrollment or is an enrolled member of your tribe, the tribe would have to be notified about the proceedings. If the tribe has not been notified, it might invalidate anything they've done legally thus far. This is what happens in dependency cases at the very least. Hopefully your tribe will be willing to claim jurisdiction, which they can do even if the case's jurisdiction is in another state. Bingo, you hit the head on the nail. The only thing I would supplement is that not only dependency cases will trigger ICWA protections. Cases like the current one also will require compliance with ICWA. Fuego Pants says, assuming the boyfriend truthfully discloses the child's tribal affiliation, the tribe will be notified of the adoption. You need to talk to your tribal representative. Let them know you want the child. The tribe has the right to intervene in the case at any time as long as the tribe agrees the child is an Indian child under the definition laid out under ICWA. Is your tribe federally recognized? Because if not, ICWA doesn't apply. Update 25th of May. I met with our ICW representative in Anadarko, and he says that we can prepare a case. We won't be able to get birth records for a few weeks, since all record lobbies near us are closed due to COVID-19. Also, those who asked private messaged me for names and locations to help locate my nephew in Oregon. Thank you, but it would be irresponsible for me to give out that information, especially the little information we have is tenuous at best. I've been trying to reach the boyfriend for more information about the potential adoption and my nephew's location for the last few days, but he has yet to reply since our last conversation above. I'm not sure what to do if he doesn't reply. I'll try and keep this post updated, but we were warned that we may have a couple long months ahead. Thank you everyone for your help. And our next one I've already covered before, but there is an update to it now. By user, Parking Spot Help 1192. titled, Condo Board is telling me as of June 5th, the parking spot I own will be converted into a handicapped spot, but there are no other parking spots available. Is this legal? This started back in December. I own a parking spot that is right next to the 3 existing handicapped spots in my condo building. I have paperwork that says I am the owner of the parking spot A5. Me and my wife inherited this condo from my mother. In December, apparently a new tenant moved in, who requires a handicapped parking spot. However, our building already does not have enough parking for everyone. For roughly a 100 units, we have maybe 50 spots tops. Back then, I was asked by the condo board if I was willing to give up my spot for these people who needed a handicapped spot. I was okay with it until they explained there were no other available spots. Instead, they wanted me to sign over my parking spot in exchange for nothing. Apparently in 2022, when the parking garage expansion will take place, I will be the first on that list to receive one of the new spots. Until then, apparently I'm shit out of luck, since this is downtown Toronto, where parking is extremely limited. At that point, both me and my wife refused to sign anything. In February, the condo board yet again tried to get me to sign paperwork, and I refused. They offered to pay for a spot for me roughly 10 blocks away at another building. I told the condo board yet again I am not interested. They have tried to guilt both me and my wife numerous times about this. The tenant who needs the spot has approached me and my wife several times about how we are making her life a living hell. In April, the condo board during the board meeting thing put a vote asking for people to vote for the conversion of parking spots A5 through to A7 to be converted into 2 handicapped parking spots. The motion passed. However, neither me or the people in A6/A7 are budging so far. Today, I received a letter stating that as of June 5th, 2020, I will no longer be the owner of parking spot A5. I didn't sign any paperwork and have told our condo board to pee off. My questions are, is this legal? Can the condo board take away our parking spot that we own? And do we have any sort of legal alternatives? Just to clarify, I am not really trying to be a dick. However, these new people who moved in bought the unit fully knowing they were not buying a parking spot. Instead, my understanding is they expect the apartment building is to provide them a handicapped spot free of charge. Location, Toronto, Ontario. Update. Condo board is telling me as of June 5th, the parking spot I own will be converted into a handicapped spot, but there are no other parking spots available. Is this legal? Thank you for all the advice. We ended up talking to a lawyer on Tuesday, and we paid him a small amount to write a nicely worded letter indicating that our condo board had no right to do what they are doing. The condo board has more or less agreed that they are in the wrong. Yeah, screw them. And will be pursuing other alternatives to create handicapped parking for this new owner. Today, the owner who wants the spot came to my door, telling me that I need to move my car because as of today, it belonged to her. I explained to her what the condo board told me and she got very upset. For now, I am not going to move my car because I think she could be more of an issue than my condo board. To answer a few questions, I did offer the condo board an option to buy my spot for a stupidly high price of $200,000 and a guaranteed spot when they increase parking space. They are not interested. I do in fact own this parking spot. It is owned by me and deeded to me. There is no street parking and stopping in front of our building. Handicapped spots are actually owned and managed by the building. The issue came to heads when the people who bought the condo had a verbal promise that there was available handicapped parking. However, not long after making that promise, another tenant needed a handicapped parking spot due to him being stuck in a wheelchair, so the spot ended up going to him. The actual owner, who was complaining about this, actually owns a non-handicapped spot. However, they refused to trade it because they have 2 vehicles. Their other vehicle is one of those specialized minivans for wheelchairs. What are they doing complaining then? Jesus. Finally, the owner who has been making all of this fuss has been trying to take the condo board to court over this. Anyways, thank you Legaladvice for your help. Why does the owner have 2 vehicles? Get rid of one. It's Ontario, Toronto. You can't just strong-arm someone out of a spot and then force them to take one 10 blocks away. Dear Lord, that is an ungodly amount of walking for one spot, and you already own your own. What an asshole. Actually, screw them. I don't care if they have a specialized minivan. That's all you need. What's wrong with people? STBX is threatening me with getting sent to prison because I made a mistake on the taxes and may have stupidly or inadvertently committed a crime. Florida. Every time I talk about leaving, he says things such as, he will crush every aspect of my life, or he will make sure I can't be happy. He will then text me a bunch of "can we stop fighting" texts later in the day. I feel insane, so sorry if this is jumbled. In February, we got our W-2S and saw we were going to owe the IRS money. First time in my life. He then flips out and says he will file for a divorce because why is he going to pay to be married to me? He's a peach. What? We ended up not filing right away since why should the IRS get our money sooner than necessary? Fast forward to the height of the pandemic. I work in a grocery store. My brain is fudging fried between people being terrible and this man blowing up my phone with his insane accusations every day of me having an affair because we were in a pandemic, and my hours are longer as a grocery store employee. I go home, look at taxes again on the online program we use, and it now says we are getting a refund. I pick married, filing jointly, not thinking about it, sign the electronic signatures, as he has in the past years when he filed our taxes while I was at work. I also decided to set up a bank account in my name, only for it to be deposited into, as this man has $20,000 in a bank account that I didn't know about until after I signed a post-nuptial, and I have zero in savings. He had also gotten a $50,000 settlement from a car accident, which he put 100% down on a new, second car for himself. I just wanted this money for me, and I know it was crappy. Fast forward, he logs into the tax software, sees I'm getting a refund, and flips when he sees that the money is going into a bank account he didn't know about. I offer to give him half once the money comes in to be fair. I thought I filed correctly, but turns out his income was missing. So I immediately corrected the IRS form and sent the money back to the IRS. STBX is telling me no, I committed tax fraud as he has me on recording through our home monitoring system that I offered to split the money with him, attempting to make him an accessory. I offered to split the money with him before I realized I made a mistake filing. He also tells me I committed identity theft by signing his electronic signature, he's signed mine before when he filled our taxes, and theft from trying to steal his tax money. I don't know what to do as he now lords the recording over my head and tells me he doesn't want our son to see me thrown in prison. He is using it as one of his many threats to force me to stay and work on the relationship instead of abandoning my family. Sorry if this is jumbled, I'm really tired. Fire away. Nobody is going to jail over a minor filing error. You can relax. You should stop communicating with him and start talking to divorce attorneys. Any issues with assets and tax refunds will be dealt with by the divorce settlement. You've already solved the problem. You're done. There is nothing left to do. At least with the taxes, the divorce is a different story. So it was identity theft or anything to sign electronically, I had to put in a number I picked for me and him. He is saying it was identity theft, etc. I am a CPA. In the strictest terms, you should not have signed for him, but he will have an impossible time trying to get anyone to believe that it was identity theft, and you corrected the issues. This video and signing the document is totally a non-starter, and means basically nothing. If it was a serious crime, more than half of married couples who file taxes would be getting put in jail. He can speculate. He can also eat crap. Get a consultation with a divorce attorney. Just you and the attorney. It shouldn't be expensive, if it costs anything at all, to have a simple chat with him about the basics and what you want to do. To find an attorney, contact any local attorney in your area. They should be able to lead you to someone relevant, or you can reach out to your local bar association for another referral. Get a divorce attorney. Let them go through it, and they will help. Stop talking to your ex unless it's specifically about the kiddo. Might be time to start clicking the married, filing separately button on this one. As a tax accountant who prepares US and Canadian returns for people, I can say I wouldn't worry about it at all. People make mistakes on forms all the time, and sending in adjustments is extremely common. You would have to have actual intent to commit fraud, and would have to theoretically try to take the money and just keep quiet about it for anything major to happen. Submitting the adjustment and paying the new balance is the solution to at least that problem. So I guess my take on this is it just sounds like domestic violence, or escalation to domestic violence waiting to happen. The husband knows that she's actually done nothing wrong. He's just gaslighting her, and I believe that I'm using this term correctly, in that he's done so much wrong and hid so much from her in the past that he can just use this as leverage to continue to wail on his wife, and I don't agree with that at all. I think she needs to get away from him or report something here, because she seems like in a scary position here. Update to my soon-to-be ex and threatening me with tax fraud, etc., Florida. So today, after a verbal confrontation in my job's parking lot, my managers are going to have trespassing paperwork written up so he cannot harass me or intimidate me. I love them. He called me saying that he put off having me arrested last week. What an asshole. He also says, I went to the police with all of my evidence and you were looking at 4 felony counts. Don't know what the 4th one was. And I told the police to hold off for your sake because I don't want you to be handcuffed and arrested and humiliated at work. The officer gave me a fist bump and told me, I gotcha, bro. I said I'm calling an attorney and hung up on the phone. He had, what? How'd you get a fist bump through the phone? Spoke to my lawyer and he said, and a kind Redditor has messaged me privately with the same phrase, trying to help me, that he is just using emotional terrorism and I have to stop responding. He said there is no way the police are going to take tax fraud evidence from a citizen to go and arrest a person, especially that the tax situation was fixed and the IRS was paid back and the filing was already amended. So hopefully that is done. Thank you everyone who helped put my mind at ease. A lot of people don't understand how hard it is to let go of the fear grip that emotional abusers have on you, and how much panic and anxiety it causes. Absolutely, and this was the logical conclusion that this one was going to come to if those conditions were met, and I'm very happy that it did. Coming from me with no legal background besides, lawyer friends, it's easy to see he was just being manipulative and that his accusations held no water, and I'm very glad that it ended the way it did. Posted by user Resident Gain, titled, Estranged husband overdosed after our last court date, being sued for wrongful death, Illinois. This is as convoluted and embarrassing as the title suggests. I'll try to be concise. 14th of March 2019. Left husband after 6 years of documented physical abuse. Time/date stamped screenshots, photo and police reports, copies of which I still possess. 25th of March 2019, was granted no contact order pending disposition of felony domestic battery complaint. 13th of September 2019, petitioned for divorce. This case was continued pending disposition of criminal matter. 19th of February 2020, criminal matter was set for trial in April. Later that day, husband takes fatal dose of fentanyl and what is ruled an accidental overdose. 8th of March 2020, divorce case is dismissed, certificate of death is attached to my petition, as opposed to his countersuit. Not sure if this is germane. This morning, was served a summons to appear in the wrongful death suit his sister has filed against me. She is seeking $175,000 in damages, which is coincidentally the amount of debt for which I have been liable had he won the divorce. She alleges that I fabricated the abuse for the sole purpose of inflicting emotional harm, and with the express intent of causing his relapse and suicide. Obviously, this is all BS. Obviously, I will respond. I have a stack of documentation almost 2 inches thick in my file cabinet, as well as digital copies, MRIs and CAT scans of a fractured orbital socket, discharge paperwork and photographs of 2nd and 3rd degree burns, emails and text messages in which he threatens to hurt or kill me, photos of ligature marks across my neck. My question to you guys, how on earth do I go about finding an attorney to represent me, and how expensive is this going to be? Vague ballpark, not actuals or anything close. I guess I'm trying to figure out how tightly I need to gird my loins for the crap storm ahead. I literally just pulled myself out of a giant hole that I had to dig to get away from him safely and to get the mental health support that I needed. I'm panicking that I will not be able to scrape together enough for a retainer, and I'm going to have to fight pro se. Edit, this is in Cook County, Illinois. Edit 2, I haven't heard back from my divorce attorney, but I spoke with a friend last night who is a corporate litigator and is going to send me some referrals. When I read him the text of her complaint, he actually laughed out loud and said while my situation was unfortunate and I do need to retain counsel, I shouldn't have anything to worry about because her claims are so outlandish. Thanks for all your advice. I will give an update once this is resolved. Don't you just love when the family comes after you as well in court just to make matters a lot worse? It's like, it's not good enough that her brother is dead. Now the sister has to come out and do it, and that is absolutely disgusting. You need to find an attorney with a civil practice, with bonus points for family law experience. If you are represented during the divorce, your attorney there can probably refer you. Based on what you said, this is a pretty safe case for you. You obviously need to file an answer to avoid a default, but I would be very surprised if this survives a motion to dismiss. You might also check your homeowner's policy to see if this accusation of wrongful death is covered and if they have a duty to defend. Thank you for your response. I was being represented pro bono through a non-profit, and I don't think qualify for their services anymore. I did reach out for referrals though. I'm mostly trying to stem my panic that I won't be able to afford representation, and I'm going to screw up the paperwork somehow, and being found in default. What little savings I've been able to amass has been wiped out by COVID-related medical bills. Did your husband have any assets? Is there any chance there's money in the estate you ought to be inheriting? No, he had $175,000 in premarital students, which coincidentally is what she or his estate is seeking, and the firm representing her or it is the same firm that was representing him in both matters. Student debt does not continue after death in most cases. Only federally backed student loans are dismissed after debt. Private loans are still the responsibility of the estate. Bane Kilgrind says, reach out to them. They might have an idea of who can help you if they don't have the mandate. I did. I just feel guilty for bothering now when I make too much money to qualify for their services. Domestic abuse incidents have skyrocketed since the shelter-in-place order. You shouldn't. This is what they are for. It all matters. Likely, part of their services is giving people advice even when they don't qualify, and they likely have a bank of resources that they can easily share with you with little extra effort. Not just bonus points for lawyer type, it is very important to get a lawyer who specializes in the field your legal case and dispute is in. Also, if he died before you were divorced / the divorce was finalized, you may need to look into that estate stuff, with a lawyer of course. So estate / family lawyer of office who is both, so they can check with each other. Even if you did fabricate the abuse claims, there is an extremely tenuous link between you making false allegations against him and him overdosing on drugs. He chose to use drugs, and the overdose was an accident of his own making. I see, at most, a very casual link between your actions and his death. However, a wrongful death claim requires more than a casual link. That being said, some jurisdictions, not Illinois, allow intentional infliction of emotional distress as a basis for a wrongful death action, though the sister would have the burden of proving that you fabricated the claims. You will want to consult with a civil defense attorney ASAP. I really needed to hear this. While I am most certainly not fabricating anything, he was a terrifying drunk as the poorly patched holes in my walls and broken furniture attest. I didn't realize until this morning that I've been feeling guilty, because she is right, that I knew if I left he'd probably end up dead, like many drug addicts. That's part of why I stayed so long. Thank you so much for reminding me that I have nothing to feel guilty for. And someone else says to that original comment, kind of. Plaintiff's estate, assuming the sister has standing pursuant to a valid appointment by a probate court, can absolutely plead an IIED count in addition to wrongful death and survivorship counts under Illinois law. Illinois permits pleadings in the alternative, and one set of facts need not to be the basis for another. Common negligence can serve as the basis for the WD claims. Plaintiff doesn't need to win at the pleading stage, just plead a series of facts that could win. Consult with an attorney ASAP and edited for clarity. For reference, her rationale is that, in addition to fabricating the abuse, because I knew he had a history of drug abuse and suicidal threats and attempts, I should have known that he would intentionally overdose if I left him and took our dog. I'm sort of paraphrasing, but the complaint specifically asserts that claim. Alright, how ridiculous is that claim? You can't just know for a fact that someone is going to overdose if you escape abuse. What, is she living in Fantasyland? What do I know? I'm a Dog says, well, I don't know if we can trust his legal advice, but definitely seek out someone. You can look up legal aid clinics. Is she being represented by an attorney? Litigating in Cook County is a different animal than anywhere else. Be sure to talk to an attorney before you file anything with the courts. With the coronavirus orders in place, the judges are incredibly liberal right now with the extensions, but they usually are anyways. This case sounds like BS, but depending on if she is represented, in my experience, judges are reluctant to dismiss cases filed by reputable attorneys, even if they seem like total BS. If she is representing herself, then it is much more likely that you get in and out with a simple motion to dismiss. I am not giving you legal advice here, just my experience practicing in Cook County. She is being represented. I thought it was the same firm that defended him, but further research indicates it's a bankruptcy firm. Update. Sister-in-law suing for WD after ex's OD, Cook County, Illinois. I was initially going to wait to update until I had completely resolved the matter, but with court postponed until July, I figured I'd go ahead. In my original post, I did not mention that I work for a synagogue and am in the process of becoming a rabbi, because it did not feel germane at the time. However, an entire congregation learned of my situation in real time because the process server rang my doorbell in the middle of me reading Torah during Shabbat services on Zoom. By Saturday night, I had received several offers of pro bono representation. Interestingly, because I refused to admit the unmasked stranger demanding entry to my residence, he left the summons without me signing for it. So there are now 3 distinct grounds for dismissal. My attorney is also pursuing sanctions against her counselor. I cannot adequately express my gratitude to those of you who commented on my original post. You armed my prefrontal cortex with adequate ammunition to keep my amygdala at bay. I suppose thank you will have to suffice. Stay safe, be well, and best wishes to you all. Now that is r/I am very smart if I ever saw it. Posted by user Sue What Do We Have Here? Titled Right of Way Through Property WV. I'm posting this on behalf of my dad who lives in West Virginia. Great song, that one. For some background, in 2009 he bought a piece of property that's about 90 odd acres. The land was relatively undeveloped, save for a couple logging roads at the front entrance. The land is roughly a trapezoidal shape, with the most narrow portion being up against the road for about 100 yards. The only clear entrance is there, as the other 3 sides border on other properties. When purchasing the property, my dad had the survey updated and gathered a local terrain map. After a lot of digging, my dad found the owners of the surrounding properties, 4 in total, and contacted them to let them know about the purchase and the updated property lines. The surveyors, or who thoroughly marked everything, with stakes and orange tags. 2 of the properties are pretty much vacant or used for ATV trails. The other 2 have homes on them. Over the years, my dad has slowly worked on clearing ATV trails and whatnot, and actually built a home that was finished in 2018. While clearing brush in 2015-ish, he found a deer feeder and a game camera in an old hayfield in the north corner. He duct taped signs to both saying to remove the feeder and camera or he will destroy them. Both the feeder and camera were moved about 20 yards, but still within my dad's property. Since they were there, my dad trashed the deer feeder. It was a plastic homemade setup and pitched the camera. A few weeks after, the owner of the camera and a feeder, a neighbor named John, threatened my cousin with a handgun. My cousin was there, with permission from my dad, in blaze orange, riding the cleared trails on his ATV. Cousin called the cops for trespassing and the threat. The cops removed John, and he spent the night in jail. Since then, things have been extremely sour with John and his son, who live on the adjacent property. Despite this, we have evidence that John has been on and used my dad's property until my dad formally moved on the property in 2018. Now to the meat of the problem. John contacted my father, informing him that he, John, will be filing for a right-of-way through the property once his home is built. According to the information my dad had from the purchase, John owns the property parallel to my dad's with access to the road. While digging around, my dad found that John separated his property in two last year, early 2019, and sold the lower portion, the piece adjacent to the road, to his son. Does John have a leg to stand on? My dad Get it, guys? My dad mapped out that right-of-way trail and road would cut off the hayfield and join to his private driveway 50 yards from his, my dad's home. He's done all this to have privacy and seclusion, and now someone is trying to put up a road right through the almost middle. Does West Virginia even have a right-of-way law for private property? Edit to link, Dad's land. That's right, guys. There's a Microsoft Paint document here of the land. What does it mean? It looks like a weird kite to me. There's got a question mark there. I don't know what any of this is. This is the land split over there. It doesn't make any sense to me, but nonetheless, I'm going to keep it in the background. The black at the bottom is the existing highway. Purple shape is Dad's land, with the dot being his home. The red is roughly his private driveway. Blue is John's land, with the green being the new lower portion to the sun. Large blue circle is roughly John's build site. Pink is owned with a home. We don't know how big or where their access is. The yellow and orange on the side are the ATV properties. Edit 2. Dad is now also concerned about his gate at the head of the property where the driveway meets the road. It is a cattle gate that is locked with chain and padlock. John has already had the foundation done on his building site, given that he didn't come through the property to do this. Does that help my dad in any way? Not a lawyer, but currently landlocked myself. Your dad is going to need an attorney. If there was never a road or any recorded easement for John on your dad's title, and John had access to his property via a road, then split it leaving no access, he landlocked himself. A judge would most likely make him put the easement on his son's property where the former road and access is. Your dad needs to keep the lock on his driveway gate and never let John use it, or he risks setting a precedent for a further easement. The fact that he didn't need access to build his home is a strong argument in his favor, but this is not DIY territory. I'm not a lawyer. I've had to deal with access into easements, etc. in my rural community. John has no claim on your land. The sale to his son should have included an easement to the landlocked portion. Presumably, this is how he is accessing his land now. Of course, he may try. May be worth the peace of mind to have a lawyer send him a nice letter advising him to work out access issues with his son, as you cannot help. It's been a while since I've had property, but if I remember correctly, a landowner can actually landlock himself and doesn't acquire an easement by necessity over land he has conveyed to a third party. If he had conveyed the landlocked property to his son, then the son would have acquired an easement by necessity. Yes, he should have included an easement, but he didn't, so he doesn't get a free one. This doesn't actually bear on OP's question, since the landlock postdates the division of OP's dad's land from John's. And I'm going to read this one just because I can. Can you go to your Paint app and draw a picture of the layout, then upload to Imgur and link? No need to make it pretty or anything. We have a lot of love for crappy MS Paint pictures here. Don't we ever? I'm having a bit of trouble picturing the relative positions of the properties and where he would like the right of way. Is the lot John lives on completely surrounded by other lots with no road access after selling half to his son? How does he access the land now? Are the lots developed with houses? Is there an extant right of way on the assessor's map, like the logging trails? Added a pic. A lot of it is guessed because I'm in Texas and going off pure memory in terms of property lines and maps. To our knowledge, John's new property has no other access. The lots are not heavily developed. It's a one house per several acres sort of setup. He doesn't need to access it now, considering there is no home there at present. From what we gather, he is still living in the son's home on the lower lot. I do not know about the assessor's map. Thanks. That helps make a lot of sense of it. I really like your choice of color and texture. It really brings out the life in the picture. I am seriously disappointed in the lack of excitement over your crappy MS Paint, but I digress. Congratulations to John. He's officially an idiot, absent an extant right-of-way, and the fact he split his own property that had road access and landlocked an undeveloped lot, he screwed himself. There is an extraordinarily low chance that he would prevail in court fighting to obtain use of your father's lot. I use extraordinarily low here because no, isn't a very professional way to phrase it. And technically, there is always some chance of factors we don't know here to surface, on top of the fact that it's generally not possible to decide to develop a landlocked property and decide that an adjacent lot has to give up land for access in a situation like this. The expense of litigation that one would almost assuredly lose just for spite is one of those don't cut off your nose when you're mad at your face type things. In your father's position, I'd probably just ignore him until he actually serves your father with a lawsuit trying to force the matter. Since it will cost him $10,000 at least to retain an attorney willing to do it, I'd put the chance of that happening in the no range of possibility as well. But you never know. Most of us here wouldn't be employed if there weren't so many dim-witted and splenetic people out there. Best of luck. They also save from the OP, there is no extant right-of-way on the assessor's map. Dad says logging was done, but was limited to just the property using the main entrance, and didn't expend more than 75 yards into the yard. Most of the overgrown ATV trails were done by locals and the adjacent ATV property. The only road on the survey at the time of purchase is now the private drive. And I hope this fulfilled everything you guys were looking for. There is not an update to this one, but you got a crappy MS painting out of it, so give yourself a pat on the back. We deserve this. It was beautiful. Thank you, America. Titled, HOA Parking Wars. So I moved into a small gated townhouse community a year ago, less than 40 units. I never had issues with the HOA until 2 months ago, when a new board was elected. Apparently, they want to collect the vehicle information, make, model, license plates, and owner info for all the cars in the neighborhood. Once we provide this information, they'll give us decals for our cars so they can identify people who live in the neighborhood. For guests, we'll be provided with 2 guest parking hang tags, and if you want more than 2, then you have to pay $25 per hang tag. The guest parking hang tags will show the address of owners. There is ample guest parking in the community. However, the board members feel that there are owners parking in the guest parking spots too often. But like I said, there is ample guest parking, and I've seen this happen rarely. The board also said the decals will help stop tailgating at the gate, even though the decals have no ability to open the gate. I'm assuming they think neighbors will prevent a car from entering if they don't see the neighborhood decal. There is nothing in the CCRs and bylaws that require this information to be provided, and rules about parking are clearly spelled out, and includes nothing about this new policy, quote-unquote. There was also no community vote on this issue, and most owners have said that they feel like it's unnecessary. I'm not even sure how they plan on storing our personal information once it's collected. Yeah, just store it in some overseas accounts. You maybe sell a few tidbits here and there. That sounds logical. I don't feel like I need to identify myself or my vehicles in order to drive through my neighborhood and park at my house. I also don't need the HOA policing my guests and knowing each individual that comes to my home by listing our info on the hang tags. Lastly, it's baffling that they placed a limit on the number of guest hang tags and are requiring us to pay if we want more. Can they legally enforce this even though it's not in the bylaws? Considering the behavior of the board members, I feel like this will lead to profiling and policing every car that comes into the neighborhood. Sounds like 1984 if you ask me. They can try. It all comes down to how far you're willing to challenge them. I'm not a lawyer, but based on what you've written, without a vote to establish new rules and bylaws, they likely would lose in court. Go back and read all the bylaws and rules. See if they went through procedure to create a new rule requiring this. If so, then you have to comply. If not, point it out, and notify everyone in the community, and tell them outright you will not comply. Then be on the lookout for them to try to get it through properly. Yep, I double-checked and they didn't go through the procedure. The president stopped by my house yesterday to try and get my information, and I told him we do not plan on complying. What? So what happens when you have a birthday party? This is insane. I know people complain in my neighborhood about cars parking in their part of the street. Put up flyers on your neighbor's doors. Tell them that there was no rule, according to your other comments, and ask them to question the security of this information. Who will have access to it? What stops a hacker from looking at it? I had the exact same thoughts. If I have a party, they're basically saying that I would need to buy hang tags for each additional guest vehicle. Why should we be forced to pay for my guest park in spots that are free to use on a first-come, first-served basis? I'm not even sure what they're using the money for once it's collected. It's insane. They can have Uber, just have them dropped off at the gate so they can walk the rest of the way. Sod off, Myrtle, get out of here. Definitely raise a stink. Obviously we're missing information, but their proposed solution wouldn't actually fix anything. What this almost sounds like is a local towing company contacted them to work out a deal. Car isn't stickered or tagged. It gets towed type of thing, you know? The real question is, why are owners parking in guest parking? Do their own spots suck? Do they have more cars than spots? If they've got a badger in their ass, that is the problem to solve. Our old condo association required our cars, make, model, and tag numbers, etc., and we had resident stickers in our cars. It wasn't too bad really, since we did have towing, and it saved you from getting your card towed by arse-hats who delighted in finding a car that didn't have stickers or the guest pass displayed. So I definitely agree with your thoughts that someone is ramping up for hiring a towing company to troll the neighborhood. No other reason to collect all that data suddenly. Without a tow truck, what other reason do they have to know? I didn't even think of this. You're probably right. Each owner has a driveway that can accommodate 2 cars. I'm not sure why some choose to park in the visitor's spot, but at most it's 2 to 3 people doing this in the neighborhood, and honestly isn't a problem from my perspective. I live in an apartment complex that required you to put down your information on your application. They had a tow service that would come through every night at midnight with a flashlight and their lights off, with a spotter walking in front of the truck as they slowly idled down the parking lot, and they would tow every single car that wasn't on the list. My wife and I started running out there at night and walking in front of them, yelling at people screaming really loud that they're going to tow your car. They're going to tow your car. Oh my god, that is so scummy of them. Is that legal? Does anyone know if that's actually legal? I have personal experience that I believe relates. My HOA does what it wants until you sue them because they know the cost of a lawsuit deters many people. In my case, I'm trying to get them to correct an Americans with Disabilities Act violation, although I am not disabled. I would just have liked them to correct it before the HOA got sued. Since they wouldn't, I sued them. It does affect my unit. Don't put a reminder on this though. We're in the early stages, the courts are closed, and it normally takes about 2 years to get it adjusted anyway. I have yet to see a plaintiff lose a lawsuit involving an ADA violation though. Just to clarify, the guest parking is on their land and the streets are private, not public, right? Because they don't get to say who can park on public streets. There are just parking spots in various parts of the neighborhood. Some are near the mailbox area, and there are some at the end of a few rows of townhouses. I'm assuming it's public since they're just spots in the neighborhood. I'm not for sure though, but all the spaces are clearly marked as guest parking. Posted by user Danny Balls 79, titled, "Can my HOA fine me for the time I didn't have my pet registered as a support animal?" My girlfriend and I recently moved to a new condo with our 2 cats. My HOA does not allow pets, and the penalty is a $100 fine per day for each pet. I plan on getting an ESA letter from my doc soon, but my cats have been here for 3 to 4 months now without any registration. If they ever find out, can my HOA fine me for those 3 to 4 months during which my pets were not registered as emotional support animals? Not sure if this was the right place to post, but any help or guidance is appreciated. If they've got proof, probably yes, but also you should get clarification that ESAs are allowed. There's a world of difference between ESAs and service animals, both in terms of training/responsibilities and legal protections. I've done some research, and from what I gather, an ESA letter from a doctor should cover most legal issues with a landlord or HOA. Apparently, there's some exceptions, but if you've got a letter saying your pet is prescribed, then you're technically protected under the Fair Housing Act, and some other acts that I forgot, lol. You're definitely right though, and I will clarify with my HOA. I just hope they don't decide to dig any deeper on the matter. Posted by user Free Range Feral, titled Looking for Loopholes. The HOA is controlled by the developer. The bylaws, registered with the state of Florida, state that the owner of each lot is allowed 1 vote. However, the covenants, not registered with the state, declare that each undeveloped lot, owned by the developer, is granted 10 votes per. I found conflicting info online. Some say that discrepancies between the bylaws and covenants err on the side of the covenants. Some say that the documents filled with the state are the final rule. Which document is the supreme document? Additionally, we've discovered that BOD meetings, as directed in both documents, and the BOD have not been advertised to residents, and the BOD has made rulings on issues without the required notification or an amendment to the documents. Are we in the right to disregard BOD decisions if the meeting was held without the required notification? Any board decision made at non-properly noticed meeting need to post signage at least 48 hours in advance are 100% not valid. As for the developer, it would be helpful if you posted a snippet of the area that says they have 10 votes per lot. That doesn't make sense to me. I would need to read it. Rule of thumb for hierarchy is DEC Articles Bylaws, Rules and Regs. I've seen the number of votes per lot by the developer. My last neighborhood had 4 per lot until they opened Phase 2, which went up to 8 per lot. Then Phase 3, and the final 4th phase was 16 votes per lot. It basically maintains their control until they get to like high 90% of the lots sold off. Then they basically are done anyway. Right, that's the current status. The undeveloped lots are awarded additional votes. In this situation, the bylaws state the developer gets 1 vote per lot, while the covenants award 10 votes per undeveloped lot. I'm searching for a statute that declares which document supersedes the other. If the covenants rule supreme, then the developer is granted 10 votes per lot, while if the bylaws rule supreme, then the developer only has 1 vote per lot. Gotcha, I missed that point. I would think the bylaws superseded the covenants, since it is the governing document, but I'm not a lawyer. Posted by user 8-bit coder, titled HOA is trying to force us to put down unnecessary gravel in the front of our yards. TLDR at the end. We have an HOA in Arizona that is suddenly forcing us to put gravel in our front yard. It started last year when suddenly new management came in. They immediately started sending us letters about a non-compliance of their property specifications. We had multiple emails back and forth because there is plenty of gravel in our yard. They keep telling us that we need more gravel and that the handbook says that. Well, how is it that for the 19 years of this house existing, the previous owners and us never had any notices or issues with the HOA with gravel? It's been the same thing as it was when the house was built in 2000. But as soon as the new management comes in, they start penalizing us for not having enough gravel. Through their emails, it kept getting clearer that they are really just trying to suck as much cash out of their residents as much as possible. We've been charged $75 already because of it, and worse, they are pushing it even more during coronavirus, where we are during quarantine, and are trying to pull the funds together to survive regularly, let alone afford a $1,500 cost in buying more gravel for our property. They know that corona is impacting all the families in our neighborhood, and they are taking advantage of it by pushing fees on us. We know it's not just us, as all of our neighbors have also told us about the sudden new letters coming in about missing gravel, or any other bullcrap that they seem to fit to scam us with. What is our recourse for this, and to not have to pay the fees or put down the gravel? They can't seem to understand that we need at least a year to gather the funds. We don't want to pursue lawyers because of the costs, but if we do, is there a high chance that we have a good case against the HOA? Who is benefiting from these added demands? The Homeowners Association should be representing you and your neighbors and be comprised of a cross-section of homeowners in your neighborhood. Does the HOA president own the gravel company? HOAs usually hold annual meetings. Did you attend the last one, and what were the budgetary needs? If you pay HOA fees, it should cover basic common area maintenance. If they're nickel and diming over fees for minor things, Maybe there's a bigger expense they're trying to fund that they're not telling you about. Or maybe management is pocketing a commission for fines over violations. The people that are benefiting are the ones forcing us to get gravel. I'd be really suspicious of a relationship between any members of the HOA board and the company that provides and spreads that gravel. Also, I find it very hard to believe that even the most stringent HOA actually quantified in their regulations how much gravel exactly is acceptable. I would push back every time an email, writing, or some kind of written record to be provided with a clause of the HOA rules you're exactly violating prior to paying any fine. When in doubt, spend the money you would have paid in fees and gravel on one well-worded notice from a lawyer on an official letterhead of a law firm. Worked wonders for me. Opie doesn't really describe the contents of the letter. Summer monsoons are usually strong enough in Arizona to wash away gravel from yards. Those only occur a few times a year, but a few times a year times 19 may result in a less than uniform allocation of gravel across the publicly visible yard, and could also result in patches of dirt and gravel, or just gravel sitting on top of dirt when the bylaws require an inch or two of gravel. I too would be suspicious of whether a relationship with a gravel and landscaping company exists nonetheless. An HOA is made up of homeowners. Have they been holding public meetings? Have you gone to any of these meetings? Have you voted in any HOA elections? When you refer to management, are you referring to a company hired by the HOA? The meetings are public, but very hard to get to. They make it purposefully difficult to see how to participate. Why do HOAs even exist? I've never heard of them outside of the US. It seems madness to me to sign up to an organization into which you must pay money to be told how to decorate your own property. If you're in a condo, HOAs are necessary for the administration and upkeep of commonly owned property. In hypothesis, it makes the neighborhood more attractive and thus raises property values. This hypothesis has been disproven, but few HOA members realize that. They're intended to prevent homes in a neighborhood from falling into disrepair by having everyone adhere to the same rules. In my experience, many of those rules aren't quantitative and instead qualitative and subjective. Combine the vagueness with militaristic-minded busybodies who think they wield a position of influence, and the result is an overbearing hand. Case in point, my HOA attempted to force me to repaint our exterior simply because other homeowners decided to repaint theirs, with different colors than they had originally. Their letter included the statute they claimed I was in violation of. I replied using their statute and the subjective words it employed to my benefit. I never heard another peep about my paint. Posted by user Gilligan Syrup, titled, Iowa. My dad's house is serviced by a community well that is now owned by an HOA. They want him to join the HOA to keep using the well. Does he have any defense? My father owns a house in an area with a community well. Back in the 90s, when he bought the land and had the house built, the neighborhood was all supposed to be developed. My father knew someone involved in the plans and bought a plot as soon as the opportunity came up. Meanwhile, the well was put in by a well service, and the way the contract worked, the well service owns all the wells and lines. However, there was some drama with the development company, and the rest of the development didn't end up happening at the time. They eventually sold it all to a different development company, and that new company developed the block as an HOA neighborhood. They asked my dad to join. He said no. It was never really an issue again until recently. After the new area was developed, the well company has always managed the well and bills people directly. They pay a very small amount that covers the cost of maintaining the well as well. Extremely cheap. Damn it, why is that funny? Apparently, the well supervisor recently wanted to get out of the well biz, but not a lot of well services want to own the well. Well. They want to service them on contracts, but don't want to be the actual owners these days. So they sold the well back to the HOA, who now owns it, and hired a new company to do the maintenance. Now, here is a failure on our part. My dad received notice in the mail about this from the HOA. However, they have sent him mail in the past that was not relevant to him, so he thought the recent mailings were crap and ignored it. So apparently there were 3 community meetings held about this that he did not attend. They've left him voicemails, but he admits that he listens to the first 2 seconds, thought it was political spam, and ignored it. Now they have finally gotten in touch with him that since the well is owned by the HOA, they are treating it as an HOA benefit, and they can't give those benefits to non-members. They told him they understand that he doesn't want to be held to HOA covenants just to keep getting the same water he always has. But since the HOA is taking on the burden of the well, they need to be fair to members and not have someone who isn't paying for HOA benefits receiving them. It sounded exactly as slimy as it reads. They are offering him a special allowance to join the HOA, but not to be held to those covenants such as house colors and fences and all those other things, but so he can use the well. I don't know if they're being slimy and pulling a fast one without a legal basis, or if my father should be legitimately concerned. Should he get a lawyer? He should absolutely get a lawyer. Unfortunately, that's all we can tell you here. Water use rights are complicated, and there's simply no way we can even begin to guess what legal options exist for your father here. I will say that it's worth bracing for the possibility your father will need to drill his own well if he decides against joining the HOA. The fact they sent multiple mailings and called strongly suggests they've already gone through the entire administrative process of what is in essence taking ownership and control of a water source. There are notification requirements involved. The letters would have informed him of his rights as to the method and process of how to intervene in a matter that would have required the HOA to continue providing water. If I am correct in guessing this, then his right to appeal or seek remedy may be considerably limited. Again, this is 100% need an attorney territory. We can't be of much use here, I'm afraid. Best of luck. Angry Stapler says, just to chime in, not an expert on legal specifics, but I'm a hydrogeologist. Typically, installing wells will cost you $4,000 plus, as it depends on the depth of the aquifer from the ground surface, $40 to $60 per foot drilled. Also, if wells are privately owned, they may have rights to that aquifer. From my understanding, it's typically enforced by a minimum spacing between your new wells and theirs. Depending on your property, you might not be able to even install a well based off its proximity. I would defiantly look into it though, as laws are different between different provinces and states. Each says, I'd expect more, but I'd absolutely defer to you on that one. I briefly looked into Iowa well depth average since so many people were suggesting just drill a new well, so I could try to explain to them why that's not such an easy solution. They seem to on average run 300 to 500 foot at an average cost on the higher end of the range, although there are wells approaching 3,000 plus feet in some areas. There are some at 100 feet, which would be great, assuming it's kosher to drill on OP's land, and so on. I paid $8,000 for a well in 1995-ish, and that was fun. For what it's worth, when there's a proximal well that withdraws or materially alters cost of water service, there are usually statutory limitations placed on the well owner from enforcing restraint against someone who needs access. This is one of those things that makes questions like OP's impossible for us to get into, as they're almost violently fact-dependent. Not a lawyer, but depending on the area, even if they sent letters and called, it might not be enough to serve the required papers. OP's dad has no link with the HOA and a history of them trying to convince him to join. So for the sake of his well-being, he had no reason to open the letters. It might not be an excuse in every jurisdiction, but an attorney could check if there is a requirement for these papers to be served by a process server, or at least to be sent in registered mail. Once again, the best bet would be contacting a lawyer about this. I am a lawyer, and there isn't a personal service requirement, nor requirement to send certified mail for an administrative process of this nature in any jurisdiction that I am aware of. The father, not belonging to the HOA, isn't relative to that effect. Not opening mail is not an excuse to not know what a letter contains. I brought it up as it seems clear that the HOA made numerous attempts to communicate with the homeowner here, which suggests that they've long since applied for and were approved of the transfer of usage rights from shared to private. That's a bell that can't be unrung, and important to realize. It's unlikely they'd put as much effort as they did into doing it without A, really needing to, or B, making sure the law and requirements for notification process is followed to a T. People ignoring response requests of this nature are thorns in the side of the entities trying to complete the transfer, and they will send someone to your house to let you know, hey, last opportunity here, because of the expensive litigation when someone claims to have not been notified. I'm not saying that it's impossible that notification requirements weren't met, but it's almost assuredly not a failure of delivery. Old mate Bob Sconce says, realistically, that special allowance sounds like a reasonable proposal. The covenants and such are the main reason people don't want to join HOAs. If they are letting him continue to have water without having to be subject to all of those restrictions, that's a good thing. Let's say that the old well company sold to a new well company who just jacked up the prices. Why would that be any different? That said, private water systems are frequently regulated by the state, and the state may dictate what rates are allowed to be. So, if the new rates are significantly higher than the old ones, he might want to hire a lawyer to look into that. Or, the thin edge of the wedge, unless OP's dad gets a decent lawyer to carefully negotiate that and its limits, I foresee some a-hole HOA board using it as a tool for harassment. Also, I seriously doubt that they'd extend that allowance to the next owner of the house, if it's put up for a sale, unless OP's dad's lawyer makes sure that's part of the deal. Sorry for the word salad, guys. I just thought that was all really interesting information. If you guys do want more comments, do tell me down below, because there is so many more that I could read that is all amazing information. Update: my dad's house is serviced by a community well that is now owned by an HOA. Hi all, I wanted to update on the outcome of this. Sorry, it's honestly a pretty boring outcome. No cool courtroom outbursts at all, sadly. It turns out that there were just some liars, and there was never actually a legal problem in the first place. My dad was just the victim of the HOA trying to scam him. Here is my original thread. The summary is that my dad lives in a house served by a community well that is next to an HOA, but my dad is not a part of it. The HOA told my dad that they now own the well and that he needs to join the HOA and effectively pay them $800 a month to use the well service plus the actual water bill on top of it. He did end up getting a lawyer to see him ASAP. The lawyer told him the first thing he needed to do was get records of ownership for the well and try to get his hands on the details of the sale. However, after a couple of days, he said he was having issues getting up-to-date records and was waiting to hear back from a contact at the county because he wasn't sure if COVID had delayed records filings or what. Then my dad got a surprise, a water bill from the original well servicer, right on time for their 3 times a year billing. Obviously, that's odd, considering he's been told that they don't own the well anymore, and he called them up. It turns out he was just lied to. The well servicer was never looking to get out of the well business permanently, but rather was looking to contract out the day-to-day testing services of the well to another company, because many of the wells they service now require more testing than they did years ago, and they no longer have the manpower to do all of it themselves. But they were not selling the well, simply hiring an independent contractor to drive around and do well stuff all day. During that time, the HOA had asked them to attend an HOA meeting so residents could ask questions about things like filtration, and they mentioned it at the meeting to let residents know that they would be seeing a new person going around doing testing, and wanted to let them know because the testing involves taking samples from individual properties, and they didn't want anyone to be freaked out. So, when the HOA told my dad they now owned the well, they were just plain lying. When the HOA said they had a new company doing the servicing, they were half truthful. A new company was doing the testing, but the HOA had nothing to do with it. The contract is between the original well servicer and the individual guy they're contracting out to. The original well servicer also told my dad that the HOA had reached out and informed them around the same time they were contacting my dad, that they were taking over handling billing, and that the well servicer should bill the HOA for all properties, and the HOA would then include it in the HOA dues billing to streamline things, for residents claiming that it would make their residents' lives easier if only they had to keep track of one bill and not multiple. However, the HOA actually has no authority to just declare this, and the well servicer just outright told them no. They will continue to bill individual properties. The timing of this coincides with when they started contacting my dad, so they were just trying to pull a fast one on everyone. The well servicer is confident that the HOA has zero legal authority over the well situation and says they respected the HOA in an organizational capacity, like calling meetings so residents could ask questions, and were professionally annoyed with them trying to insert themselves into billing, but they were not aware that the HOA was claiming to own the well. They told my dad that he should not give the HOA any money for water servicing or accept water servicing related information from them in any way. So, going back around to the lawyer, my dad got an appointment with the lawyer to tell him all this, and the lawyer had his own news that matched up entirely. The reason he wasn't finding up-to-date records following the supposed sale was because he doesn't believe a legitimate sale has happened. He thinks my dad was just getting scammed. So all in all, my dad will continue to use the well as he always has. He's pretty angry that he had to spend a bunch of money to find out what he already knew, that this HOA is made of dicks. But we are definitely breathing a sigh of relief. Meanwhile, as for the HOA, my father's lawyer has suggested that there may be room for legal action against the HOA reps for what was basically fraudulent claims. My father doesn't want to spend the money pursuing it at this time, but the well servicer did ask for copies of everything he received from the HOA because they want to review it with their own lawyer. Thanks to everyone who gave advice, we're grateful for it, and also for the fact that we didn't have to use most of it, haha. But I will add that it was good advice nonetheless, even if it was word soup, word pasta, word ravioli. Time for you guys to see what Markee is up to in the outro screen. Never ever again will I ever live somewhere that's managed by an HOA. So this is the second complex we've lived at over the years that's been managed by an HOA. We're renters, fortunately, so we can eventually leave and move to a non-HOA managed residence in the future with relative ease. But these are the things that bothered me the most about this particular HOA. The complex we live in is a 100-home PUD. Beautiful park-like grounds, but very provincial suburban neighbours. We don't like this aspect. That's managed by an HOA comprised of board members who are homeowners here, but it's mainly managed by an off-site corporate HOA representative who really sucks, who has an out-of-sight, out-of-mind attitude. She doesn't live here, so to her, it's just another job. Oftentimes, it's hard to get a response from her as she manages other places and is overextended. We have known the HOA to be essentially ineffective and very slow to action. Currently, the HOA isn't setting the tone for safety in the time of COVID at this complex. While we understand that they can't enforce mask wearing and social distancing ordinances, they could send out notifications. As it stands now, there isn't much social distancing being practiced, and kids from different households hang out together for hours unmasked. Said kids also seem to not receive any guidance from parents, so they will not move out of the way on the public pathways when they see someone coming. It seems to be a universal truth that HOAs are inefficient, bureaucratic entities that take more than they give, and that is certainly the case with the one we have to deal with. The current issue is that they want to prune the trees months earlier than they normally would, right in the middle of baby bird season. We've noticed that they currently use a tree trimming service that is really bad at their job and butchers the hell out of trees. I'm a tree person, and this really irks me. In other words, they went with the lowest bidder, which is very typical. As renters, we've not been able to find any type of satisfactory recourse regarding the village alcoholic that lives across the field from us. He likes to play frisbee golf along the pathway, which runs right next to the side of our house, and as he gets more drunk, he sounds like a deranged crackhead yelling and screaming. I am not exaggerating. Since he is a long-time homeowner and is friends with the people on the board, they look the other way and have probably tossed out legitimate complaints against him being a major nuisance. Of course, I'm sure that if someone carried on like that outside of their living room, there would be hell to pay. The HOA, this has to do with being based on an inefficient bureaucratic model, is unable to adapt to changing circumstances, and is by definition exclusionary, as they won't let long-term renters, like one of us, to sit on the board, even if you have the ability to provide helpful, excellent feedback to help make the community better for everyone. Thus, it is undemocratic. We are still here because of the financial reasons, which isn't an uncommon scenario for most people these days. but I swear that this will be the last time I ever deal with an HOA. I really don't think it's HOA territory to enforce any kind of COVID restrictions, except maybe close the community gym and pool. It's definitely not their responsibility to manage residents who drink too much. Call the cops for that. Vetting a tree groomer is something they should do. Attend the meetings and voice your displeasure. Really, it just sounds like you want a more strict and controlling HOA. I'll pass. As long as they pay the bills and keep the common spaces from falling apart, I'm happy. They have no business telling my kids they can't play outside with their friends. Beautiful park-like grounds but very provincial suburban neighbours, we don't like this aspect. Can't help but lol at this after reading the Krennic list of complaints. Right, if the park-like grounds are so beautiful, then their landscaping company is probably doing a pretty good job already. Opie is picky about his trees. Being good at mowing and weed eating is not the same as being a trained arborist who knows how to trim each different kind of tree to maximize its health and beauty. Just like knowing how to give a dog a bath doesn't magically teach you not to shave dogs with undercoats because it messes them up when they grow back. This is a new one for this sub. You're basically complaining that the HOA isn't militant enough for your liking. They're allowing children of different households to play together. This person is like the exact opposite of everything people in this sub hate about HOAs. I think we found Sidewalk Susan. Oh my god, if you just looked it up on YouTube, it's that woman, I don't know if you can even call her that at this point, just spraying down the chalk on the sidewalk. No happiness, no fun, go away. These are not HOA issues. The management company and board can only enforce the HOA rules. If someone is causing a disturbance for being drunk, then call the police. They also have no authority to enforce social distancing. Is this the kind of control you really want an HOA to have? If the person was being loud, the police wouldn't even come to my HOA. Private roads and stuff, you know? They would just say to complain to the HOA. Sounds like a police department issue then. Police, fire, and ambulances have 100% access to private roads and have a special code to get into gated communities. If the police refuse to enforce the rules regarding public disturbances, how in the world is HOA board comprised of private citizens supposed to enforce it? And would you really want the HOA to have that kind of power in your life? They already have a huge impact on daily life. Why give them more power? An HOA of 100 homes doesn't need an on-site manager and likely can't afford one. A manager should never live in a community that she manages. It's a terrible conflict of interests, and people would be knocking on her door 24/7. HOAs are always slow to action. Getting anything done takes meetings and discussions, and more meetings, and 2 months of back and forth questions, and a meeting to vote on whatever was finally agreed to after the back and forth. Your drunk neighbor has nothing to do with you being a renter. HOAs can only employ civil remedies. They might be able to send a letter to your neighbor, maybe fine him, if your documents allow fines that is, and maybe even file a lawsuit. Time-consuming and very expensive. But they can't make him stop drinking and going outside any more than grocery stores can make people put their carts back. This is an inconsiderate world. Any public drunkenness is a police matter anyway. As a renter, you are not a member of the association. The governing documents may not allow non-members to serve on the board. Amending the governing documents is only slightly less difficult than amending the Constitution. So yes, it's hard for HOAs to adapt. Why not make a suggestion about the trees? How do you know they went with the lowest bidder? And even if they did, that may be what the majority of the dues-paying owners, which you are not, want. Very good questions for Karen. Or Sidewalk Susan, as we're now applying to her. She didn't respond to anything, so gah! Why are you ignoring us, Sidewalk Susan? Are you scared? Are you scared of me, Sidewalk Susan? Our next post is by user Paleontologist OK 5060, titled, Property Manager Kicked Out My Contractors. What would you do? I'll elaborate on the subject line. My first homeowner experience has been in a condominium association, and it's been one hell of a nightmare. I've been through it all. Started as the clueless one who had no idea what he was signing up for, been disgusted with the state of things, ran for the board to change it, got on the board, saw the same issue continue, and when I stood up against them, lost my board seat. Finally, I've realized there is no saving the place and moved out, prepping the place for sale. My condo is a townhome, in a complex with many traditional condominiums in a high-rise. We are all held to the same rules, despite the fact that townhome units are much easier to access, and we share the same parking area, with assigned parking spaces for each unit. My unit suffered some water damage due to the negligence of the condo association, but my attorney just couldn't do anything about it, or so it seems. The case has been sitting for over a year. It seemed my best course of action was to move out and have some internal repairs made. Unfortunately for me, COVID-19 came into play, and the board and property manager found a new opportunity to make up crap. Per our bylaws, internal works in a condo is permitted so long as we have adequate insurance for the contractors. The contractors can't work any earlier than 9 AM or later than 5 PM, or work on Sundays. As long as the work is internal to a unit, the architectural board has no say. Unfortunately, the current board seems to ignore this, and their lackeys do as well. As the COVID-19 crisis started, it was announced that no contractors would be allowed in. At the time, I couldn't get any contractors willing to work, so no big deal. I finally got some with the adequate insurance, and they allow them in, sort of. Now, we're expected to submit everything through a portal, wait back for approval, and there's a waiting list. No more than 3 units at a time can have contractors working on them. None of this is in the bylaws. My attorney even pointed out that health and safety as a power/responsibility of the HOA is a slippery slope they shouldn't want to be involved in, but they are. Also, keep in mind what I said about rules applying to the whole complex that don't make sense for all units. People can enter and leave my unit without stepping foot in an enclosed common area, unlike the high-rise units. I decided it was best to just get this done, without raising a fuss, so I got the insurance proof in hand and let the contractors in. I'm not living there, so they can park in my parking space. Of course, someone noticed. The property manager told them to leave or he would tow their vehicle. He then made all nicey nice and said that all I had to do was submit some paperwork, he would approve it, and they could be let back in. He then went on to say he would disable the gate access token that I had given them to ensure that they can't come back. I filled out some paperwork, but I've not heard a response. I highly doubt the prompt turnaround mentioned in the above conversation will come to pass. I've yet to deal with a property manager at this place that isn't a two-faced lying piece of crap, but maybe this one won't be. I don't have high hopes. So, what would you do? This isn't a "can they do this?" kind of post. My own understanding is that they have no right to tell my contractors to leave, to tow or threaten to tow cars in my spots. I am fully paid up on my dues and have never been behind, or that someone can't be working in my unit. I also don't think they have a right to disable my access token. I've not checked, but I strongly suspect all of my tokens are disabled, effectively barring me from entry. They've done all these things anyway, because I guess they know you can't do anything about it except execute a long drawn-out legal battle. If you're looking to sell soon, that's obviously not something you're going to do. If you cannot get in with your token, call the cops. You still own the place, and it's normally illegal to stop you from going into your property. First thing is get a lawyer who deals with HOAs. Regular lawyers get lost in the paperwork. I'll consider the cops' option, but who knows how they will respond in this city. As for the attorneys, well, my attorney claims their firm does deal with HOAs. I learned from being on the board and through reading up here and in other places, even all HOA attorneys are not created equal. The sad fact is, a homeowner will almost always be outgunned against an HOA. Firms that defend HOAs are able to do that and only that, so they know that part of the law well. There are few lawyers that are specialized in dealing with HOAs, and likely none that make it their entire practice area. If you don't want to be outgunned, look at big law as an option, but it will cost you. The major firms have near unlimited resources, for which you will pay, but you will outgun the HOA. If there is a settlement conference, the HOA may have one lawyer and a paralegal. With big law, you can have as many as you can afford sit there and look intimidating. It's an expensive strategy, which may or may not be the most effective strategy. I'm thinking if I had that sort of money, I'd just sell the place to an as-is seller and be done with it. Instead, I'll have to consider foreclosure as a pricey option of last resort. It is normally illegal to stop you from going into your property. This is true. You still own your place, and barring you from entering your building is illegal unless there are very specific reasons, e.g. unlivable conditions determined by the state, foreclosure, natural disaster, crime scene, restraining orders, etc. The property is arguably uninhabitable, but that's not a position the HOA would want to take. The state of the place is due to their lack of maintenance or exterior, common element walls. Well, in that case, you might also consider a city and county building inspection to be performed. A formal one, not just a quick look-see, but one with full paperwork that is sealed by private notary. This will turn the screws a bit for the HOA. Some good advice here is posted by Crimson7. 0. I'm not a lawyer. 1. Test your access. If it doesn't work, call the non-emergency number for the police and advise them that you're being unlawfully restricted from gaining entry to your property. 2. Advise your contractor that he can park in your space, and if anyone attempts to have him towed, to call the emergency number. Write this in a letter and have the contractor tape it to his window with your cellular phone number on the paper for contact. If they tow, it is theft. The tow truck driver will be personally liable and criminally liable too if he tows the truck. 3. Record any and all contact with the HOA. What was said, by who, and when. That property manager is personally liable for restricting your access to the property if he did. Proving it without recordings, video, or detailed notes, preferably with witnesses, is hard. If he did restrict your access to the property, it gives weight to your argument that he took it upon himself to cause this problem for you, making him personally liable for the situation. Notice the liable usage? If they are going to play dirty, so should you. Go to small claims court and file a suit against any individual involved in the process of blocking you from maintaining or accessing your property. Make the suit for the maximum amount allowed in that court, usually between $5,000 and $20,000. This will get their attention and make sure they understand that you are beyond tired of their stupid games. Once the suits are filed, post them to whatever community board is available, be it bulletin, webpage, Facebook group, whatever, so that all residents are aware of the suits and the reason for the suits. This is not libel. The court case is a public record. When they don't bother to show up to court to answer for their stupidity, you get a default win. What state is this in? Georgia, where it seems HOAs can do anything they want, the owner loses, the HOA and crooked management firms win. Our next post is by user Hickatul, titled, How to Get Rid of an HOA. A good friend of mine has about 4 years ago inherited the house of his grandparents. He decided to live there for the time being till he has decided what to do with the house. He grew up in it, so he did not really want to sell it. Not even a week after he moved in, he got a visit from a neighborhood committee. They said they are the 3 board members of the HOA and are here so he can sign his membership papers. They were extremely nosy and rude. For example, one tried to get into the garage without so much as asking. When he stopped him and asked him where he wanted to go, he had the audacity to say, "I need to check your garage, if everything is in order. I have a right to do this bi-weekly, and denying me access is an offense that will cost a fine." He then had enough of their audacity and kicked them out of the house. While doing so, one of the board members shoved some papers into his face and told him he needed to sign this right now. He had been living there a week already, and these papers had to be signed before moving in. Once they were gone, he took a look at the papers. They were fudging ridiculous, and gave the HOA rights that were simply unfrickin' real. They had, for example, a right to visit your home bi-weekly, and check things like that you do not use the garage for storage, don't have gasoline on containers in your garage, same goes for gas. You had to mow your lawn every week, snow had to be shoveled every 2 hours when it snowed, starting at 5 o'clock in the morning. You could not park more than 1 car on your grounds, except inside the garage, and a ton of other bullcrap. A few days later, they came back, and asked him why he didn't sign the papers yet. They also wanted to check the garage again. This time, he would not even let them in, and told them that he would never become a member of their stupid club. To them, that meant war. Within a week, they had sent him fines north of $1,000. Some of them were for denying them access to his home, each worth $250. My friend simply did not take them seriously and used their stupid letters to help fire his grill. Then came the day where they went extremely too far. He came back, and one of the board members had broken into his garage, stood in it, and was writing things down on his notepad. But that was not even the worst part. He had 2 beautiful oak trees in front of his house. They had been planted by his great-grandparents when they were newlyweds and moved into the house. The HOA was in the process of taking them down. Tree law! Tree law! They had called a professional crew for this. One was already so damaged, basically all the twigs were already down, that it was just a stump that was left. The other one they had just started with. He fudging lost it. He told the tree crew to stop right the hell now and explained to them that he was the owner and what they did was highly illegal. They had no idea, since the board member claimed these trees were in violation of the rules, since supposedly too many leaves went into the neighbor's garden. He had told them that that was no legal reason to put them down, but the board member claimed I had given my okay because the trees were in violation of the rules of the HOA. He looked it up later. They actually had a bylaw that if a garden produces more than one 40-liter sack of leaves within 2 weeks, the garden owner needs to take down the offending trees within 2 weeks. He told them he would overlook them trespassing if they would be witnesses in court for him. Then he called the cops on the board members for trespassing, breaking and entering. They'd actually used a bolt cutter to get into the garage, and he had always had it closed with a big fudging bike lock after they had tried to get in twice before. The trial must have been glorious. Not only did they have to repay him for the lock and the tree, which was worth a crap ton of money, north of $50,000 if I remember right, plus damages for the second tree. He had a professional tree person look at it so all the damage healed properly, which alone cost nearly $1,000. But these idiots actually thought the trial would have been unfair, and tried to fight it, which probably cost them an additional $10,000 to $15,000 in lawyers and court costs. All in all, this trial must have cost them over $120,000. Then he went to civil court and sued them for emotional damage. He told them how much the trees meant to him, since his great-grandparents had planted them with seeds from the home country. He really laid it on as thick as he could. Plus, he felt threatened by the HOA, and can hardly sleep because he always feared they try to get into his house. The court actually bought it and gave him $500,000 plus the costs for a state-of-the-art alarm system, so he can feel safe again in his own home. So, put all together, he cost the HOA nearly $750,000. They had to file for bankruptcy and get a person to check the books so my friend would get his money. The best is for last. The mediator found out that these 3 pricks had been defrauding the HOA for well over 10 years, and were giving out as many fines as they possibly could so they could use it to bolster their income. All 3 had to sell their houses, so they could pay out my friend. Now he is for most people one of their favorite people living there, and he constantly gets invited over for grilling and whatnot. You see, most people never wanted the HOA in the first place, but the board member practically forced them to sign the contract, claiming it would not be optional, and if they did not sign before moving in, it would be a $500 fine. Only 6 of the over 50 members actually wanted this HOA, and people think that they did get part of the action as rewards for spying out their neighbors to find violations. So basically, if you don't sign papers agreeing to let the HOA have authority over you, they can't fine you because they don't have the authority over you, right? They said it's mandatory for you to volunteer your signature for this. Screw that. There is something called a deed restriction that can require you to join the HOA when buying the house, but that would come into play when the house was bought and transferred. Such restrictions usually only exist when the house is part of a subdivision where an HOA was set up before the house was ever sold. Assuming the story is accurate, there was no deed restriction on the property, so the HOA had to use hard sale tactics to get people to sign. OP says, the reason there wasn't one was that he inherited the house, a case for which they had no bylaws saying you have to join or join automatically, which they had ion cases where you buy a property there, Guess they meant no cases, but okay. Though I do not really understand how it can be legal to force someone to join for any reason. Doesn't one of the amendments guarantee freedom of association? If there was a deed restriction, inheritance would not matter. The deed would require membership. You don't inherit a house, you inherit a deed to a house. As for freedom of association, you are not required to buy a house with an HOA, so buy a different house if you don't want one. In cases of inheritance, they'd tell you to just sell the house if you attempted a legal challenge to the deed restriction. I guess then his Grams was never a member in the first place. Need to ask him for that detail, but as far as I remember, it had to do with the fact that he inherited it. It's actually a requirement on the seller. He signed a contract agreeing that he would only sell to the people who signed the HOA membership contract. As such, people who buy the house sign the contract first, then the house contract, and are now also beholden to only sell to others. But I have seen that they cannot enforce this when a house is inherited by a last will and testament of the previous owner. HOA membership is contractual and cannot be willed. It does not follow the house or the land, unless the HOA actually owns the land and you merely lease the land from them. The house itself may be willed, but not the land, since the person who died didn't own the land. Then it's a done battle because they can enforce some rules, but not others. Rules pertaining to use of the land fall under regular landlord and tenant laws can be enforced, but others that don't pertain specifically to the property they live on can't. And in regards to the part where they're in the garage, sounds like a good time to clean my shotgun. OP says, "Bwahahaha." But no joke, looking for illegal firearms was one of the reasons they claimed why they did this. Plus, people stockpiling gasoline and gas in there, creating a fire hazard and other ridiculous crap. Believe me, there was so much more bullcrap I did not even mention, like demanding that your lawn must always be perfectly watered, but you could get fined for consuming too much communal water. Basically a catch-22, of which they had quite a few to make money. There's no way they would be able to tell if someone's guns were legal or not just by looking. Also, how did they expect you to mow your lawns without a gas can to fill the mower with? Easy. Put your mower on a trailer, which you're not allowed to store on your property, and tow it to the gas station. I know. I'm aware of how utterly ridiculous their arguments are, especially since even these reasons should not grant you a right to get into other people's properties. Imagine that there are some expensive power tools in there, and they're gone when you come home since they left the garage open after they could not close it after breaking the lock. G'day there guys, Outro Markee here. Just wanted to say thank you so much for watching today's episode. I hope you really enjoyed it. Hope you enjoyed it as much as I enjoyed making it. Now with that said, we have some special mentions. Everyone that signed up for my Patreon, everyone that's a channel member, you guys all know who you are. I'm going to start putting you on screen in the near future. Sorry, I'm very lazy, but I do love each and every one of you, and you all know that. If you want to join, there is links down in the description below. If you want to be a channel member, there's a join button next to subscribe. It helps me out immensely. Also, I have a second channel that does memes. It's called Markee 2. It should be on screen here now. If you like memes and you want to laugh with me, it's some not so politically correct content all the time. Hope you enjoy it. Click on the screen, subscribe, and enjoy the memes. That's all I have for today, and I'll see you in the next episode. Bye.